And welcome back. How you doing? We got a question 2 here from the February 2016 bar exam in torts, and ironically, it is a intentional torts, all intentional torts essay. So let's take a look at the cause of the question. There's 3 causes of the question here, and so let's see who's suing who. And just so you know, the difference between a criminal case and a civil case, which people sometimes get confused about, is with a criminal case, you're going to have the state or the prosecution or the people or the Commonwealth. On the bar exam, it's going to be like the state or the prosecution versus a defendant, okay, a criminal defendant who could be anybody, it could be any party. In a civil case, it's brought by a private individual. It's not brought by the state's attorney. So when you have, see, Nancy, and also they're asking for, in criminal, they try to charge you and they get jail time. Whereas in civil, you're looking for dollar signs. So let's see, it says what tort causes, I mean, they actually go out of their way and say tort here. Sometimes they don't. So a tort cause of action, if any, by Nancy. But the fact that Nancy is bringing suit against Jack, that tells you it's a civil, not criminal, because Nancy could not bring a criminal case against Jack. She could only bring a civil case. Nancy versus Jack, and says what causes of action and how are they likely to fare? So, standard question. 2, what about Jack versus Ben? Jack's the defendant here, the plaintiff here. And then Paul versus Jack. Oh, we got a lot of Jack going on. All right, finally got a plaintiff here. And I think the N for Nancy stands for neighbor. Jack, I don't know why they call him Jack. He ends up being, well, I guess you can't really call him a defendant because he shows up as a plaintiff here. And who the hell is B? Ben. I don't know who B is. What I'm trying to say is usually they use the first initial as a meaning for something. Like Paul is plaintiff. You know, Wanda is witness. V is victor. O is officer. You know, stuff like that. Henry is husband. Wanda is wife or witness. Okay, let's take a look at it. So again, how do you handle this? Just go in chronological order. It's that simple. You don't need checklists. You don't need templates. You don't need any kind of an approach. Here's the approach. You read the call of the question. You read the fact pattern carefully. You break it down. You think logically, and you answer it. It's that simple. Don't make it any harder than it is. This exam is not that difficult. Try not to make it any harder than it is. Okay, so Jack believed that extraterrestrial aliens, ET, had come back, come down to Earth, were living undercover as humans, and were planning a full-scale invasion in the future. This guy's out of his freaking mind. Okay, clearly they're making him out of his mind. But insanity is a defense in criminal case. You cannot escape civil liability based on your mental state. Think about that for a second. You cannot escape civil liability, which means you're going to be, even a crazy person is going to have to pay out of pocket for the damages they cause, period, at the end, all right? You're not going to be able to use that as an offense. The first thing I see is, does he have the intent or his mental state? And the answer is, a crazy person's held to the same standard as a sane person, all right? Because look, we don't want to punish and lock up a crazy person, and you know, we don't want to put him in jail. Yeah, the guy's not right. He's mentally challenged. You know, what are you going to do? You put this guy away? But between me, an innocent victim, and this crazy lunatic who just damaged my property, that motherfucker's going to pay. So that's why in civil cases, insanity or mental capacity is not going to be defense. And don't forget, in negligence, the standard of care is they consider physical characteristics, whether you're in a wheelchair, paraplegic, maybe you have one arm, or whatever the case is, your physical characteristics will determine the reasonable standard of care, but your mental characteristics will not be considered, again, for the rationale that I just mentioned. All right, first thing we have, Jack's mental state. This guy's a crazy lunatic. You don't need to mention it twice. The examiners aren't going to be impressed that you copied and pasted it just so you have 1,800 words on the page. Don't do that. Okay. He believed his next door neighbor, there's neighbor Nancy, was one of these aliens. I'd love to see what this broad looks like. Okay. So we got one day, Nancy called Jack on the phone to complain that Jack's children were playing in her yard. Okay. Well, we have Jack, he got his children, so we have trespass to land, right? Well, and the reason why I would bring this up is because Jack's not going to be liable for trespass to land. He is not vicariously liable, and yes, vicarious liability can apply to intentional torts. It's true. Jack will not be vicariously liable because parents are not vicariously liable for their children's torts. Jack may be liable for his own negligence in failing to properly supervise the children. We don't have those facts, but parents are not vicariously liable for the intentional torts of their children. And because this is really just an intentional torts essay, you're going to see that you're going to want to bring in I think they cover the gamut of intentional torts. They cover like all but one. Okay, here we go. So we got Nancy called Jack on the phone to complain his children are playing. And he yelled, hey, his children can play wherever they want. So apparently the apple doesn't fall far from the tree. Got crazy little kids, you got a crazy parent. He also said that he was going to kill her. All right, he's going to kill her, so he's making a threat. We might have an assault. He's gonna, hey, I'm gonna kill you, whatever. Is it an imminent threat? He is across the street. That's a discussion. Also, telling you're going to kill people say that all the time without being liable for assault, although your damages would be very weak. So no one's going to take the case to court. The next day, Nancy approached Jack, now she's getting in his face, who was playing in his yard with his children. So he's minding his own business this time. She reminded him to keep his children out of the yard. Oh, they love these neighborly disputes. Jack picked up the chainsaw and said, when the invasion comes, I'm going to use this baby to cut your head off. So now we got this lunatic with a chainsaw coming at his neighbor while he's on his own property. But again, so we have assault. We have actually 2 assaults. And yes, you would discuss both of them and you would discuss them both separately. First assault is going to kill you. Don't forget, he did that on the phone. He was across the street. The second assault would be cut your head off with the chainsaw. But he says, I'm going to do that when the invasion comes. So are either of these imminent? And I don't know if, Ethan, I don't know if I'm going to be able to get the board down here, if this is like where it ends. Everything's good? Okay, got it. So cut your, imminent, cut your head off. Again, one, he's on the phone, he's across the street, so there's probably no real threat of harm. And when the invasion comes, let's be honest, is there really going to be who knows? We could be thousands of years away from that. But in this crazy guy's mind, it could be right now. So, question whether that's imminent. And again, the answer is, I don't know, and I personally don't care. I'm just going to address it. I'm not trying to be correct on an essay. I'm not trying to solve things on an essay. I'm trying to discuss things. Now, keep in mind, some issues there's clearly a right or wrong answer. All right? You can't sentence a minor to death. Simple as that. You just can't sentence a minor to death. It's a clear-cut issue. Other things like whether or not what the person intended or whether something was reasonable. Sometimes there's not going to be a clear-cut answer to those things. So don't really look for the answer. I don't really care if this is imminent. It doesn't seem to me to be imminent. That would probably be the better conclusion. But it doesn't matter how you conclude. Just discuss how it could possibly be both if you feel that that's a possible wobbler, if you will, like right in the line. Okay, and also the fact that this guy took out a chainsaw, that's a little abnormal behavior. Don't you think that exceeds the bounds of decency in a civilized society? There we go. We got IED. Because that's pretty extreme and outrageous conduct. And yeah, sure, would you catch that? Hopefully you would. Anytime you notice that a lunatic is putting a chainsaw and threatening to cut your head off after they just threatened to kill you the day before, yeah, you could see that's pretty egregious and out of there. So as long as she suffered severe emotional distress, then we have a claim for IAED. So we have the extreme and outrageous conduct, which is a check. And do we have, suffered severe emotional distress? That's the question. And again, because the facts are bare on that, all I'm going to write in my answer is, if she did suffer severe emotional distress, if she can prove that that's what she suffered, then she'll prevail on a claim for IAED. Okay, moving on. So we got trespass to land, but that's his kids, assault, the 2 different types of assault, the IAED. And again, his intent, his mental state is that. From the other side of the street, so apparently that's all that really goes to call 1. Okay, almost there. So essentially that whole entire paragraph really went to call 1, or the first 3 paragraphs went to call 1 essentially. Okay, let me do that. Okay, from across the side of the street, Ben saw Jack angrily raising his chainsaw at Nancy. Ben ran across the street and knocked Jack to the ground and injured him. So Jack is suing Ben. First of all, he ran across the street and knocked Jack to the ground. Well, Jack, wasn't he playing in his own yard with his own children? And there's the trespass to land. So even if you didn't catch it here, you caught it here. I'm surprised the examiners would do that twice, to be honest with you. So it tells me they may have not looked for it in either here or here. Because I think they were looking for vicarious liability here. And I assume they were. And then this trespass to land would probably go to like a necessity because to defend somebody else, you might have some kind of private necessity there to enter the land. And here also he's coming to a defense. So we have self-defense, defense of others, and of course, by knocking him to the ground, well, you have the battery. So first thing he did was he came onto the guy's land, he hit him, but he's going to have the defense of others for the battery claim and probably the necessity claim for trespass. I mean, think about it. Logically speaking, do you think Ben, who's doing a pretty noble thing, should be held responsible for this kind of action? The answer is probably not, because what he's doing is actually helping society. It's not hurting society. He's coming to a woman's defense who's getting accosted by her neighbor with a chainsaw. Now, we don't know exactly where Jack is at the time. I mean, we knew he was playing on his property, but did he take the chainsaw on the street? We don't know. That's a little bit of a debate. I think they left that purposely vague. So I know I'm going to talk about trespass to land probably in one or at least both places. At least one, probably both places. Okay. Later that week, Jack decided he could no longer wait. He saw Nancy's car, which he believed to be an alien spaceship parked on the street. So he's not trespassing on her land. He snuck over to her car and cut the brake lines. Right there, he damaged her car. We have trespass to chattel. Because he cut her brake lines. Boom. I mean, he damaged her car. There's loss in value. There's also loss in use. There's clearly recognizable harm. Don't forget, trespass to chattel, you don't get nominal damages. You actually have to show actual harm. So it requires actual proof of harm. Just like IAED requires severe emotional distress. Trespass to land, you get nominal damages, on that one. Okay, battery, you also get, there doesn't need to be any actual harm. It's just that the touching is sufficient, and the same thing with assault. Okay, where we got? He believed he snuck over the car, cut the brakes, hoping that she would have a minor accident and be taught a lesson. Unaware that her car had been tampered with, Nancy lent it to Paul, and when the brakes failed to work, Paul drove off a mountain road and was severely injured. So here, Nancy lent the car to Paul. Clearly, Paul's not suing Nancy because she didn't do anything wrong. The question is, how can Paul bring a claim against Jack? And the answer is, this trespass to chattel can actually go here if you'd like, because the trespass to chattel, you can use the doctrine of transferred intent because trespass to chattel is one of the 5 intentional torts that apply transferred intent. Don't forget, it's better to look at it like this way. There's only 2 intentional torts where transferred intent does not apply. IIED and conversion. IIED and conversion, that's it. So if you just remember those 2, you don't have to remember the other 5 because it applies to all of them except for 2. So instead of remembering the list of 5, the better way to look at it is which ones doesn't it apply to? Only 2. Conversion and IIED. How about that? That's a tip. That one's free. Okay, transferred to chattel. So and we're going to use battery because what happened was he drove off a mountain road and was severely injured. So we have battery, and he would use transferred intent of the trespass to chattel on her car for the battery. Simple as that. This one wasn't a really difficult essay. There's a lot here, so there's a lot of little things that a lot of students didn't catch. For example, the 2 assaults. The fact that, well, this was extreme and outrageous conduct. Some people didn't catch that. Parents are not vicariously liable for their children. There's a trespass to land. The private necessity matter was a little questionable there. Defense of others and battery, nobody missed that. The battery here, transfer intent was probably the issue they were mostly looking for in call 3. And of course, by cutting her brake lines, she has a claim for him for trespass to chattel. She does not have a claim against Jack for battery because he didn't do anything that harmed her. He just harmed her car, which is damaging her car. The battery claim would be brought by P. All right, well, there you go. That's pretty much everything for this essay. Pretty simple one. Definitely good review of intentional torts and the doctrine of transferred intent. And yeah, that'll do it. There you go.